Second reading and committal of bills. Chair recognizes Honourable Member for Fox Hill.
Mr. Speaker, I rise to move the second reading committal of the Criminal Procedure Code Amendment Bill 2017.
Yes.
And in doing so, I recall that I was here speaking about 2 weeks ago.
Oh, thanks.
And indicated then that we would be moving what I called a companion piece of legislation to the Trafficking in Persons Act, which we did a couple of weeks ago. And that act, in talking about it, I tried to put into context the reason why we were bringing bringing that particular amendment. And so I would now like to bring the second part of that, the companion piece of legislation, to it. And I hope that the bill is not seen to be contentious in any way. But it's important to provide, again, the context of this. The first thing I'd like to say is that is to just explain what the court system is to those who may be unfamiliar with it. There are essentially two sets of courts in this country. One is a court of unlimited jurisdiction, or a superior court, which most people would recognize in common parlance as the Supreme Court. And this court has an unlimited jurisdiction, which means it has jurisdiction throughout the world and on all matters. The second kind of court is an inferior tribunal, which is largely a statutory-based court, and most people in common parlance would know it as the magistrate's court. And they are the two courts that essentially deal with criminal matters in the Bahamas. So there's a magistrate's court, there's the Supreme Court. The magistrate's court in our law has a limitation in terms of the kinds of matters it can deal with, the penalties it can impose. The more serious matters in our law, in the criminal law, are dealt with by the Supreme Court. And this is usually matters which will draw penalties over 5 years in prison. A magistrate, as I understand the present rules, cannot impose penalties, generally speaking, which are longer than 5 years in prison. But there are reasons for putting cases in one set of courts or the next. Magistrates' courts are more efficient. They don't require the impaneling of juries. And they are, in a sense, closer to the people because it is a kind of summary justice. Magistrate hears the evidence, is the trier of the fact and also of the law, makes a decision, and then the penalty is imposed. And many of the cases, including serious cases like those of the violation of the gun laws and of drugs and even trafficking in persons, are tried before magistrates. But it is possible, when there is a particularly egregious case in which the state may want to show a sterner penalty or show stronger judgment against those individuals if found guilty, there are reasons for putting cases before the Supreme Court that can draw these penalties of longer than 5 years. The other thing I should explain is that there are cases in the magistrate's court, or there are cases or charges that can be made that can be that are called triable either way. And these are cases where a defendant comes before a court and can elect, or is asked to choose, do you want this matter heard in the magistrate's court, or do you want to have this matter heard in the Supreme Court? And that's called a triable either way offense. So at the start, the magistrate, you appear before a magistrate. Most charges are brought before a magistrate, and you're given a choice in certain offenses. And these offenses are all laid out. All of this, for those of you who have a slow evening and want some illuminating reading, can go and find the Criminal Procedure Code and have a look at it, because it lays it all out there, how the charges are brought, and what your rights are when you appear before the court, and so on and so forth. So that's the Criminal Procedure Code. Some people find it exciting reading, as I say, so you have fun, those who want to have a look at it. One of the more interesting provisions, of course, in our law is that it is possible for private citizens to bring a prosecution, which we know colloquially as a private prosecution, even though the Attorney General has the power to take over and stop any prosecution. But private citizens have on occasion successfully brought private prosecutions. So that basically outlines the structure of the courts and the triable either way offenses and the summary offenses. Now, there's another thing which has been added, which you might also hear, and that's called preliminary inquiry, a preliminary inquiry. And there's another procedure you may hear about called the voluntary bill of indictment. So I'd just like to explain what those are in brief. When you're charged with offenses which have to be brought before the Supreme Court, in the old law, what would happen is you would appear before a magistrate, and the magistrate would do what's called a preliminary inquiry. And that inquiry was designed to determine whether or not there's a prima facie case for the matter to be referred to the Supreme Court. So the magistrate would hear what the Crown's evidence is. Usually the defendant would not, beside cross-examining some of the Crown's witnesses, the defendant would not offer any evidence at that point. And at the end of the presentation of the Crown, the defendant would say to the magistrate, from what I see here, there's not a prima facie case for this matter to go to the Supreme Court, and the matter should be dismissed. The magistrate would reserve his or her judgment and then come back and decide whether there's a prima facie case. And it's a very low standard. Just need to have enough evidence. So the Crown just needs to show that it has enough evidence to make out a case when it goes to the Supreme Court. Now, of course, when it goes to the Supreme Court, there's a full trial. A jury is impaneled, and the jury then decides the facts. The judge, of course, tells the jury what the law is. Now, you would know that there were complaints throughout the country for a long time on how slow these procedures are. And things were really bogged down. So in order to deal with that, there was introduced into our law something called the Voluntary Bill of Indictment. And essentially this Voluntary Bill of Indictment enables the Crown to collect all the evidence it has and present it before a magistrate, present it to the defendant or his lawyer, and say, we propose to use this evidence and go directly to the Supreme Court without a preliminary inquiry. So the question of going through the evidence over a long period of time and trying to find out a prima facie case is eliminated, and the Attorney General collects the evidence, provides it to the other side, and the matter automatically goes on to the Supreme Court, where the person is then arraigned and the trial is held. So that's a voluntary bill of indictment, and it's more particularly described as a paper procedure to move matters which are triable on information, which is another way of saying trials before the Supreme Court, trial on information to the Supreme Court for trial. Now, this procedure was used in most relevantly to this particular matter this morning in a case called the Crown or the Queen against Chevenix Hall. And it was brought before the Supreme Court on a voluntary bill of indictment, and she was convicted of the offense of trafficking in persons, contrary to the Trafficking in Persons Prevention and Suppression Act, which is Chapter 106 of the statute laws of the Bahamas. And the Trafficking in Persons Act created offenses relating to trafficking in persons. And when I spoke the last time, I explained, or tried to explain, the difference between trafficking in persons and smuggling. And trafficking in persons has basically to do with the use of force or devices to put people in a position of servitude, involuntary servitude, by keeping them in conditions where they're unable to move about freely, by, for example, withholding their passports if they're foreign workers in a country, and not allowing them to move or to leave or to hold on to their work permits. And it very often is utilized against children. And this has been described as modern-day slavery, and the world is very much sensitized to this. And so the Trafficking in Persons Act was part of the regime which was put in place in the Bahamas to show that we were serious about these offenses. That, and this most particularly affects foreign persons who brought into a country could not be kept in involuntary servitude. And we made this a specific offense in law. It doesn't apply to foreign nationals only, but can also apply to Bahamian citizens. But the whole idea is to prevent involuntary servitude. And the international community, as I said, is sensitized to this. There is a UN rapporteur who is responsible for monitoring each country and how they perform according to the international standards and agreements on trafficking in persons. But we have a neighbor to the north called the United States of America that has a particular program of monitoring and applies sanctions to countries that don't comply with what they consider to be the standards in connection with suppressing and fighting trafficking in persons. This is one of the realities of the real politic of living in the world. The big players get to dictate terms. So even though we may and are serious in our own right about fighting this, there's another external axis that we have to be concerned about. And their regime in their law has created Tier 1, Tier 2, Tier 2 watch, Tier 3. Tier 3 means that you are subject to sanctions if you don't, for not having complied with the strictures of trafficking in persons. Tier 2 watch means that you're in danger of doing so. Tier 2 means that you're not up to the highest standards and therefore you need to improve. And Tier 1 is you are at an acceptable standard as far as they're concerned. Bahamas obtained the Tier 1 status 2 years ago. It's done annually. The review period ends, I'm told, the 31st of March, so we're just up against that. And what the concern is that we do not want to fall in that system, Tier 1, Tier 2, Tier 2 watch, or Tier 3. We want to maintain the Tier 1 status. this case of Chevenix Hall was a successful prosecution. I believe it may have been, stand to be corrected on this, but may have been the first successful prosecution under the Act. And so therefore, it was a signature prosecution. And the fact that these charges were brought, we were able, in our discussions with the United States government, to convince them that the Bahamas, in part, due to the successful movement of this case, should be a Tier 1 status. So we don't want to jeopardize that. And of course, you know, there's a lot of security cooperation and support which the United States government gives, training to our military and police, and we would not want to be in danger of losing that support. Because I think if you get to Tier 3, it takes a waiver of the United States President in order to not have those sanctions. And that's something we would certainly not want to have to be negotiating or getting involved in. So this is trying to be proactive and on top of the situation. So the conviction takes place. The law was passed to ensure that we were compliant with international norms and efforts to combat activity in which people were exploited for material gain and preyed upon other persons seeking to improve their circumstances. Now, the offenses in the Trafficking in Persons Act are triable either summarily, that is, before a magistrate, or can be tried by information. So there are two types of trials you can have. You can either be tried summarily or on information. Now, when Chevenix Hall was sentenced in June of 2014, she was sentenced to 15 years imprisonment. So this is a very serious offense. So serious that a judge sentenced her to 15 years in jail. She appealed the case to the Court of Appeal, and the conviction was subsequently quashed on the basis that the offenses could not be tried on information and that there was no lawful authority to prefer a VBI, or a voluntary bill of indictment. So what the Court of Appeal said is the Crown got it wrong because the matter could not be tried before the Supreme Court, and secondly, it didn't have the authority to refer the matter by way of voluntary bill of indictment to the Supreme Court. The Crown appealed this decision to the Court of Appeal, from the Court of Appeal to the Privy Council. And the Privy Council's decision was delivered on the 17th of October last year. And it concluded that the Court of Appeal was incorrect to find that the offense could not be tried on information. So that stands up. You can still take it before the Supreme Court. But the Privy Council concluded that due to the definition of indictable offense in Section 2 of the Code, the voluntary bill of indictment procedure could not be utilized, as that procedure could only be used in relation to offenses which are triable on information only. So, in other words, you couldn't bring something before a magistrate's court and then decide while you're before the magistrate, I want to move this to the Supreme Court, and you just move it to the Supreme Court. They said that the way Section 2 defined indictable offense meant that it could only, you could only do it where something was triable on information only. So not triable either way, not summary. So, or, again, those who are interested in reading the Criminal Procedure Code, or if you've listed the offense in the third schedule of the Criminal Procedure Code. So what the Privy Council said is that this matter, in those cases where you wanted to move it to the Supreme Court, you needed to utilize the preliminary inquiry procedure, which is what I explained earlier, where the magistrate would have to find there's a prima facie case, and those of you who remember the old days, I'm not sure they're the good old days, but the old days, where these preliminary inquiries got stretched out and stretched out and stretched out and stretched out, and it took a long time before the magistrate actually concluded and then sent them over to the Supreme Court. So Privy Council said, if you want to take this to the Supreme Court under the existing law, you have to use the preliminary inquiry procedure. So now, you should note again that since the relevant offenses in the Trafficking in Persons Act can be tried either in the Magistrates Court or the Supreme Court, the decision of the Privy Council applies to this third type of case, that is, those that are triable either way. So if it's a triable either way offense, Privy Council says, sorry, you can't use these procedures. Now, even though the Trafficking in Persons Act is what this is in part we're hanging our hats on to correct this problem, there are other offenses in law which this procedure has been used for and heretofore was thought to be lawful. It should be noted that offenses under the Dangerous Drugs Act in Chapter 228 and under the Firearms Act, Chapter 213, are also impacted by this decision. And they are similarly drafted and not listed in the third schedule of the Criminal Procedure Code. Accordingly, under the present definition of indictable offense, the voluntary bill of indictment procedure cannot be used to move these types of offenses to the Supreme Court for trial. The result would be, as I said, that a preliminary inquiry would have to be used and would be necessary. And on those occasions when offenses under these acts are deemed serious enough to warrant a trial in the Supreme Court, and this would occasion delay and a significant regression in the use of judicial resources. Now, the Privy Council made a suggestion to the Crown or as to how the problem could be cured if they insisted that this was the most efficient and best way to deal with the matter. They said in the decision that the Attorney General can use the voluntary bill of information in all cases where it's a trial on information. So what you simply needed to do if you wanted to accomplish that, given the present definition, was take the word only out of the definition. So if you simply expunge the word only from the definition of indictable offenses in Section 2, you resolve this problem. So the Crown has taken that advice, and they are now proposing, Crown, we are proposing that the definition in Section 2, which now exists, should be repealed, and the new definition will read, indictable offense means any offense which is triable on information before the Supreme Court. So, any offense which is triable on information before the Supreme Court will now you'd be able to use this voluntary bill of indictment procedure under the Trafficking in Persons Act and not run afoul of what I've just described. Now, in addition, where an offense is triable either summarily or on information, that is, summarily meaning the Magistrates Court, or on information meaning the Supreme Court, and the accused person has no right to elect the mode of trial, that is, it's not triable either way, it is proposed that the power to commence a prosecution in this instance be statutorily vested in the Attorney General or her delegate. without any reference to the magistrate for determination of the mode of trial. So, in this regard, Clause 3 of the bill now seeks to include a new subsection 8 of Section 58 of the Criminal Procedure Code Act, which provides, we'll now read as follows: where an offense is triable either summarily or on information, summarily meaning in the magistrate's court, or on information meaning in the Supreme Court, and an accused person has no right to elect the mode of trial. So it's not taking away any right that the person has. It's just saying if under the law there's no right to elect the mode of trial, the prosecution of such an offense can be commenced on behalf of the Crown either summarily or on information as permitted by the Code, without any reference to the magistrate for determination of the mode of trial. So for efficiency's sake, this amendment will ensure that the matter can go, if the Attorney General believes it's more efficient, that the case is serious enough that it can go directly before the Supreme Court. So that's what the bill, in summary, is seeking to do. I know it's not the most exciting material, but these things have to be done. It's what you call kind of tidying up exercise. I think, as from the Foreign Ministry's perspective, having accomplished this before the 31st of March would be something which we hope is in our arsenal to be utilized. Yes, I was trying to think that quiver is the word, eh? Yeah, an arrow in the quiver to speak to our partners to the northeast and say that we are seeking to be compliant with the international norms and taking this matter seriously, that these cases can be brought before the Supreme Court and dealt with accordingly with the appropriate penalties. With that, I think that outlines effectively the policy behind the Act and explains what we are seeking to do, and I so move.